Can you have more than one personal representative? The answer is yes. So let's back up and talk about some terms. What is a personal representative? That is the person who is in charge of your will, making sure your will is carried out. A will has effect only upon your death. Upon your death, you have named a personal representative to carry out the terms of your will. The court will give the personal representative legal authority under letters testamentary. Commonly, the personal representative is known as the executor of your will. So that's who a personal representative is. Now, can you have more than one? Yes, you absolutely can. You can have co-personal representatives. Why would you do that? Well, maybe you want more people involved with administering your will. That is something that the court will allow. However, the court will probably not give them authority to act independently, which means that they will have to act jointly, your co-personal representatives. So they'll both have to sign off on any decision that is made, the sale of your house or whatever they have to do, they'll both have to sign off on it jointly. Whenever you put people in a decision-making position and require them to act jointly and not independently, you are setting things up for trouble. Why is that? Well, you might think that they get along just fine right now, but after your death, let's say you put your two kids as co-personal representatives of your estate, things might go sideways for them. And if that happens, then the court will become involved and make the final determination. Whenever I say the court is involved in making decisions, what that means is there's going to be more money from your estate expended to administer your estate. Typically, we do not recommend co-decision makers, especially co-personal representatives. We prefer that you choose someone who you know will be competent to act, and if they can't act, then name a successor.